I'm in Dallas right now, getting ready and getting set up to make a presentation at the Texas Advanced Employment Law Seminar tomorrow to a bunch of lawyers from all over Texas. But I want to talk to you about a particular person that's making a presentation tomorrow and what he does with non-compete. So, one of the presenters tomorrow is a judge from Houston who has an elegant way to handle non-compete lawsuits filed in his court where the employer seeks an injunctive relief. So, in a typical non-compete lawsuit, an employer will file that lawsuit and then rush to court asking for an emergency relief. It's in the form of an injunctive relief, enjoining or stopping the employee from working for a competitor for sometimes up to a year, sometimes 2 years. And the result is that employee will be out of work because they can't take that job, and they'll lose that job because they're enjoined from working for that employer for up to a year or 2 years. So this judge has a condition. He might grant the injunctive relief, but he requires that the employer post a bond that's the equivalent of the duration of the non-compete. So I'll give you an example. If an employer files a lawsuit in bad faith on a non-compete and seeks injunctive relief, stopping the employee from working for, let's say, a year, the judge would then seek a bond and require that the employer deposit a bond that is 1 year's worth of salary for that employee. So if the employee lost money and the employer's lawsuit, it turns out to be filed in bad faith, then that employee will be able to cash in on that bond and be able to recover up to a year of pay. And so that creates a disincentive for employers to file bad faith non-compete, seek injunctive relief, because there's now a repercussion. Whatever the employee lost in income, the employer may end up having to bear it. So I think that's pretty elegant, and I would like to see more judges handle non-competes in this manner. Okay, back to work.